proceed.
Good morning. May it please the court, Maureen Piercy on behalf of the appellant, Evanston Insurance Company. One little housekeeping issue I would like to address, it ties into later in the argument. Late in the day on Friday, there was a notice of supplemental authority filed by appellee Conan Graham. The attorneys that filed the supplemental authority are also counsel in the case that they filed, which is dated March 15th of this year. And they cite the supplemental authority to support their factual statement. I think it goes without saying that our record on appeal has already been established, and we are not taking new facts at the appellate level because appellate courts are not fact-finding courts. And with that aside, if the court would like to discuss that any further, I'd be happy to address it. But with that aside, I'd like to just proceed. This case emanates from an assignment for the benefits of creditors. Conan Graham had a claim, not a lawsuit, but had made a claim against an insured that was insured by both Everest Denali and Evanston. Evanston is the excess carrier. The insured is Sonny Glassbrenner. They filed the ABC proceeding. And during that proceeding, Conan Graham filed a proof of claim. They did timely file their proof of claim. However, the assignee, Mr. Hyman, moved to approve and close out the ABC proceeding. This is before, this doesn't take into account anything related to Conan Graham's claim. It says we've distributed the assets. It was approximately $8,000 and we'd like to close it out. The court approves that. After that happens, there's a motion filed to allow the Conan Graham claim. They did file an amended claim, proof of claim. So we have an order approving the final report on December 17th of 2021. On December 20th, 2021, December 20th, 2021, there's a settlement agreement executed between Conan Graham, Everest, the primary carrier, and Mr. Hyman, the assignee.
And he executes this at a time the trial court ordered that his powers were over?
Correct. So
I have an earlier question for you, and forgive me for borrowing bankruptcy terminology, but I will because I think it helps to make the point. There's an insurance policy that arguably provides coverage for negligence. Is that benefit, because it arises from a contract, an asset of the debtor's estate?
I think I would say as to the primary policy, yes. As to the
asset of the estate, doesn't the trustee or the assignee have to make a decision whether or not to abandon the asset? I'm concerned about the procedure, whether the resolution of this claim is done properly by tracking the asset of the estate rather than a proof of claim filed by an outside creditor. So, because in bankruptcy court, if there's no equity, no cash value, they would release the automatic stay, allow you to litigate it to judgment, and bring it back before the trustee, in this case, the assignee. Nothing here is happening, and I'm wondering, is part of the issues here caused by the procedures that were embarked upon?
Well, that's exactly what we're complaining about, is the procedure of how this went down. Now, I understand the argument that the other side is making is that they had to file a proof of claim here. But again, we have, as far as Everest goes, they were a primary insurer and their duty to defend arose once that claim is made. But as an excess carrier, you're kind of sitting out there and you have no obligation or duty to defend or indemnify until that primary policy is exhausted.
What is the prejudice that the excess carrier has suffered? And I understand that you've made arguments concerning bad faith, potential bad faith exposure, although I'm going to tell you before you answer, I'm struggling with how those apply in this situation. I think that you've cited some cases that are distinguishable on the facts and the circumstances leading up to where the excess carrier came into play. But you're litigating coverage in the district court. If you win there, none of this matters. lose if you win on coverage. If you lose on coverage, you're faced with a $1.8 million claim that you would probably prefer to have been an $8,000 claim, i.e. that the primary carrier would have treated this as 2 occurrences. But you'd still be defending at least 800,000 in here. And I understand also that you have some beef with how the proof of claim was accepted. But tell me, why should we do anything? What's ripe here until your coverage action is over?
Okay, I have a two-part answer to that. First of all, the prejudice itself, and I'll go through that in a minute, is in the order, but the bar provision, and I see where you're getting at with that question. The bar provision in the court's order, sorry, I'm getting a little feedback on my line here. I thought you were speaking. The bar provision itself says upon issuance of Everest settlement payment, no creditor, interested party, or others receiving notice of the motion shall have the right to pursue a claim against Everest in connection with the agreement, the settlement payment, the occurrence, the claims, the amended proof of claim, or the allowed claim, or this proceeding. So that cuts any chance of, let's just say that Evanston loses in the coverage action and it owes money. At that point, let's just say worst case scenario for Evanston, they lose 100% on coverage. The court finds the amount was reasonable, et cetera, et cetera. At that point, they have an ability to go after Everest, but they've been now denied that by this order. And the exact language of this order was a requirement of Everest settlement agreement with Conan Graham.
When you say that Evanston has the ability to go after Everest if the coverage action is resolved adversely to the excess carrier. What do you, explain to me, give me in 3 dimensions, what is the excess carrier going to do to the primary carrier that is different? In what way does this bar change how the excess carrier gets to the primary carrier?
So if you read the order itself, it says no creditor, interested party, or others receiving notice can go after them. Excuse me, Your Honor.
My question is not what does the order say. My question is what's left for the excess carrier to the coverage action is resolved adversely to them. We don't have a bar, just hypothetically. What does the excess carrier get from the primary carrier at that point?
If there's no bar to coverage, then at that point, the excess carrier can say, primary, you had a duty to investigate this claim when it came in, properly investigate it, and to negotiate. And we have a record that has self-serving letters, statements from Conan Graham.
Try to save you some time. So your basic theory here is that the excess carrier has been frozen out of the possibility at the end of an adverse determination in the coverage action, which hasn't happened yet. And you're denying coverage, and you've denied it consistently. You never accepted coverage on this thing. So at the point where you get an adverse determination, your client steps into the shoes of the insured effectively and brings a bad faith claim against the primary carrier for theoretically bad faith conduct in settling this claim and achieving the bar order. Got that right so far?
Correct.
Okay, good. That's what I needed to understand. So that's what you say is the prejudice to Everest.
That is the most prejudicial, but there are some other paragraphs specifically in this order that tie into that. So these are there are findings that Everest acted in good faith, that there were extensive negotiations.
I'm trying to remember where I saw in the briefing because I don't remember that there was any sort of issue preclusion, estoppel, res judicata, et cetera, that was going to inure against Everest by virtue of the provisions of this order.
I'm sorry, Your Honor, I didn't hear the very first part of your question. I heard the end.
My question is, did the excess carrier argue in this appeal, or in the trial court for that matter, that the findings in this order would be preclusive under principles of issue preclusion, res judicata, collateral estoppel in your coverage action, or to prevent a bad faith? Where is that argument made?
So Conan Graham specifically argued that we are bound by
That's not
this.
what I'm asking. I'm asking where you argued it.
Okay, so this comes back to really coming back to the issue of what can Evanston do when it has this final order sitting out there and saying, making all of these findings. And that's the whole problem. If we are subject to those findings, then that negates any ability to bring
Let's
a
look at
claim.
some of the findings. For example, there is a finding on the two, or a statement on the two occurrences that says, you know, if there was an occurrence, there was only one. I think it's at 5C. If the alleged damage was caused by an occurrence, it was caused by a single occurrence. And how does that really operate as a finding? I mean, it starts off with if. This is a compromise that was reached in what amounts to a bankruptcy trustee's administration of an estate. And the trial court, I think under Mumford, had to do something, or Mumford's just an example, but the trial court was in a position of having to administer what amounted to a liquidation and marshaling, and the primary insurer was never gonna make that payment without the protections that would be afforded in a bankruptcy setting for the same thing, and the trial court rightly looked to that.
And I disagree that I guess this is where our disagreement is, and really comes to the meat of this, which is once Everest said, we're just going to insist that this specific language be in here, and then we're going to pay our policy and we're out. And we don't care what happens to you. That undermines the very purpose of a primary excess policy and decades of Florida precedent on the issue. Everest has an obligation when they're defending to look out not just for themselves, but to look out for the excess carrier. And that means investigating the claim, determining, a claimant can come in and demand whatever they wish.
Let me ask you a question, because I'm giving this some thought. It seems to me that your argument necessarily assumes two things: that the order creates excess coverage because the primary policy is exhausted and there's this finding or quasi-finding on one occurrence, and it bars Evanston from suing the primary for bad faith. Those are your main problems, right?
Correct.
And what I think you're asking us to do, or one view of what I think you're asking us to do, is that what you would really like is us to write an opinion saying neither of those things is true. And that would boil down to an advisory opinion for the district court to go through in the coverage action, and we can't do that. So help me understand, given where we are, you're actively litigating the coverage action. The
Correct.
trial court arguably was authorized by statute and surrounding principles of bankruptcy law that are incorporated by the statute to do things like put a bar order in, and necessarily had to make some predicate statements to make that order have context and make sense. But to the best as I can see this, until Conan Graham wins in the coverage action with your client in district court, none of this means anything.
So this is the dilemma that's created by the order. We have a final order. If we don't appeal it right away, we're bound by it, correct? And we could litigate, what does that order mean? But if we didn't appeal this at the time we appealed it, we would be out of luck, which is why we're before the court now. I would like to point out that coverage action was filed during the pendency of the ABC proceeding, and Evanston requested to the other parties to stay it, and they said, no, we're not interested. So if they really wanted the issues litigated and done in the proper order, then that could have happened here. They could have asked the court to stay, or they, perhaps a supplemental proceeding in the ABC proceeding if they wished, but that's not what happened. And again, the timeline is we have a settlement signed before the amended proof of claim has even been approved by the court. In fact, there's already a final order.
Good timing, and I just want to highlight something here.
Let me go procedurally first. We are at 15 plus.
I don't want to use, I monopolize. plenty.
I have great powers to extend time. It's the only time I have any control over the universe sitting center chair. So if you have a question, please.
Let me get my question out,
There
and
you
you
go.
can decide if you want to save it for rebuttal. Okay. The way I understand the timeline is Evanston disclaimed coverage at the outset. It didn't object to the proof of claim after it got notice of that. Its first objection was in January 2022 when it objected to the motion to approve the settlement. 3 weeks later, it filed its coverage action. And then after the parties filed the amended motion to approve the settlement, Evanston filed another objection. And so having disclaimed coverage and taken an affirmative position in the federal court in the action that it initiated, I need you to help me understand why effectively what you're asking us to do is get mixed up in what's going to happen in the federal court. And I have a problem with that. And I'm happy to hear your answer on rebuttal. I know it's a big question, and I know you've got limited time. And if you want to try to answer it now, I think Judge Castaneda has been supporting your rebuttal, but you can do whatever you want.
I will try very quickly to answer it now because I would like to reserve a few minutes if that's possible. The premise of all of this is an excess has no obligation to defend, has no obligation until the primaries limits are triggered. So a denial when it has no duty to defend is meaningless. Okay, so that's number one. Number two, Gallagher versus DuPont, which is actually supported, I believe, in Everest's brief, specifically says, even when there's a settlement and not primary excess, just a primary carrier denies coverage to their insured, the insured goes out and settles, you deny coverage, you can still challenge that settlement. You can challenge the reasonableness, you can challenge whether it was made in good faith. The findings in this one basically say it was good faith, it was reasonable. But the only basis for that is a stipulation of people who are interested in having those findings. And there's no record evidence of any sort of effort by Everest to minimize exposure or investigate. That's, I think, really the crux of it. And if it's possible, I'd like to reserve the rest of my time.
Not a problem.
Thank you.
I have tried to address the time by question and the time consumed by answer. So I think I've done the math despite my feelings in the natural sciences. We will go ahead then and begin. I believe, Mr. Toman, you are to go first, and I am to let you know when you get to A. Go ahead, sir.
Mr. Dunlap is to go first. Yeah.
Oh, no one told me he was going to go first, and I didn't ask. So the fault lies with me, not with you. Mr. Dunlap, you are on mute, and I don't think you want to be on mute for 8 minutes.
You are correct. You are correct, Your Honor. Thank you. May it please the court, Gray Dunlap representing Conan Graham. And as I mentioned earlier, we have divided our time, and I plan on addressing, to the extent necessary, points raised in connection with whether or not the trial court properly acted under Section 627 and matters related to the administration of the 727 estate. And then I'm going to hand it off to Mr. Toman to address what I'll call more specific insurance issues, particularly the issues raised by Evanston regarding potential claims against Everest.
Mr. Dunlap, let me just ask a couple of questions, and whether this is for you or Mr. Toman, I'm sure you'll either tell us the answer or you'll shift it over to him later. The court, in its order, confirmed a settlement and determined that it's $2 million+ that's at issue, or that is the valid claim. The argument that's made in the answer briefs is that if the excess carrier loses on the coverage issue, it's done. They pay the amount and so forth. Is it correct, or is it your position that the excess carrier will no longer be able to challenge the amount that is being claimed?
Your Honor, let me make sure we're talking about the same order, because there are two orders. The order which is the subject of this appeal is the order approving the amended joint motion for settlement with Everest. That order effectively allows, that order does not settle the claim that Conan Graham asserted in the ABC proceeding. What that order does is that it permits Everest to pay a $1 million primary policy limit in partial satisfaction of the previously allowed amended proof of claim. The amount of SGI, or the amount of the ABC's estate's liability and damages in connection with Conan Graham's claim, was previously established by two things. One, by operation of Chapter 727, by the following sequence of events. Conan Graham, as Evanston concedes, timely filed its proof of claim, an amended proof of claim, and I'm just going to refer to the amended proof of claim as the proof of claim. It's the operative proof of claim. And in turn, no objections were filed to that proof of claim, and at that point, the assignee, effectively the trustee of the 727 estate, filed his final report, which was ultimately approved by the trial court. And yet another order. By operation of Chapter 727, because no objections were filed to Conan Graham's proof of claim prior to the conclusion of the general administration of the ABC estate by the assignee, that claim is deemed allowed. Now, in December of 2021, there was a stipulation filed by Conan Graham and the assignee, Mr. Hyman, it's effectively a belt and suspenders filing. It requests the court to approve the proof of claim in its full amount. So
I guess just to sort of cut to the chase, is it your position that the excess carrier, if it prevails, or I'm sorry, if it loses on the coverage defense, are they entitled to challenge the amount that they owe?
No, Your Honor. In terms of, if your question is framed as, can the excess carrier, can Evanston challenge the allowed proof of claim, the answer to that question is no.
And the second part of my question is, the final order entered by the court basically precludes any claims being brought against Everest by third parties, and I think it's very broad language. I don't have it right in front of me. So to the extent there might be some claim, I'm not sure what it would be, but let's assume there's some claim that could be brought by the excess carrier. Your position is that claim would be barred based on the events before the circuit court.
Your Honor, I'm gonna defer that question to Mr. Toman.
Very good.
But let me say this to follow up with some comments by Judge LaBritte. We absolutely agree that the trial court had the authority in the context of Chapter 727 to enter this settlement order that contained the kind of bar provision that is in there. That's consistent with a whole panoply of bankruptcy cases talking about similar bar provisions and similar settlement orders involving payment of liability insurance policy proceeds. I will say that the vast majority of those cases involve mass tort claims where there were issues about the adequacy of potential liability insurance coverage versus the amount of claims that had been submitted to a bankruptcy court or a bankruptcy court administered trust versus the scenario that's before this court and was before the trial court, where you have a single claimant making a standalone claim against, in this case, the ABC debtor that would potentially be subject to insurance coverage. But the case authority is clear that it was appropriate for the trial court in the context of Chapter 727 to include the kind of bar language that's found in this order.
Mr. Dunlop, I need to ask a question and hopefully you can help me out. And it concerns two concepts that are somewhat interrelated. One is jurisdiction and the other is power. The order that you referenced, signed by Judge Williams on December 17th, indicates in paragraph 2, the assignee is hereby discharged. And in paragraph 6, the clerk is authorized to close this case. Was there any order from the trial court that reinstated the power of the assignee prior to the entry of the joint stipulation?
Yes, Your Honor. That order was
Is that in
entered.
our record then?
I apologize, Your Honor.
Would that be in our record? And if
Yes,
not,
Your Honor.
I can go check it. Okay. I'll go check again.
And let me, I have the order up, and I'm trying to find.
Because I noticed that the order signed by Judge Williams is R89 and the joint stipulation is R91. I did not see anything between those two documents, but that doesn't mean with my technological skills, I didn't miss it.
Your Honor, there was an order entered by Judge Williams on January 3rd, 2022. The title of the order is Stipulated Order Confirming Assignee's Continuing Authority to Finalize Settlement with Conan Graham, Inc. and Everest Denali Insurance Company and Assignment of Rights.
Okay, thank you. That order would have postdated the joint stipulation for the amendment of the claim, because that was December 21.
The sequence was, Your Honor, that
So we would have ratified the assignee's power to do this.
that's
And I didn't see that
correct.
anybody challenged that below, but I wanted to make sure that I wasn't missing anything. No one challenged the power of the assignee to enter this stipulation, did they?
It was not challenged in the trial court.
Thank you. Okay, you've answered my question. I don't want to take up all your time because you're at 9.
Your Honor, just pretty quickly, although I guess a very important point for the court to keep in mind is, again, the only order on appeal here is the order approving the settlement, which in terms of its significance, there are two parts. It's the payment of the $1 million policy limit, and then the bar provisions relating to potential claims back against Everest. Evanston did not appeal either the trustee's report, final report, and the order confirming that report, which under Chapter 727 had the effect of allowing Conan Graham's proof of claim, and it did not appeal the trial court's December 28, 2021 order that specifically approved the stipulation that also allowed that proof of claim and channeled Conan Graham's ability to collect on that liquidated claim specifically to the Everest and Evanston policies. That order is not the subject of any appeal. In its reply brief, Evanston argues that somehow that was an interlocutory order that got swept up with
Mr.
everything else
Dunlap,
in the
I
case.
don't know if you caught my last comment as we were talking about that order. I may run on, like a run on since I was trying to advise you, you were at 9. So,
I apologize, Your
no,
Honor.
no, that's my responsibility to get it to you clear, not your response to guess what I was, because we were talking about something else and I think I just added it on. So you are a little bit over, so you may want to bring your comments to a close within 30 seconds if you would.
I think I've made our point clear.
Okay.
We are not talking about an appeal of the order allowing the proof of claim, period. And with that, I will turn it over to Mr. Tobin.
Okay, thank you, sir. Okay. We're clear you're at zeros, counsel,
Okay.
for your
May I
start
please-
time. Not,
May it please the court, Gary Tolman on behalf of Everest Denali Insurance Company. I think, Your Honors, there are several things that are critical importance here to the issue of prejudice and generally one, the position taken by Evanston denying coverage that certainly did have an effect on the proceedings. Secondly, what action did Everest take? It paid a claim that was established by the proof of claim that, and I would think it's critical that Evanston had notice of that and did not object. And so that is what happened leading to this settlement.
So, for instance, excess carriers gripe that the order on appeal contains aside from the bar order, heard about the issues with that, but what about the part that, you know, all parties acted in good faith? And what does this do? You've heard what Evanston had to say about it. And in the briefing, they've complained that these are not the products of an evidentiary or an adversarial proceeding that would otherwise underlie findings like this. And there seems to be at least some suggestion that they feel the order may bind them in ways that are going to be prejudicial in the coverage case. Help me out with that. The trial judge just could sign off on this based on a stipulation without any proper or evidentiary predicate other than the proof of claim for 2.8 million was established.
Your Honor, I don't know that there's a requirement that evidence be submitted there. I think that this was done in the ordinary course and presented in the ordinary course and with the agreement of what would be adverse parties. And I think it's critical that Evanston, with knowledge of all this, did not either then or at any point during the proceeding come forward with any evidence that there was something irregular about this, or that in fact that Everest had not done any investigation, all that. I mean, what they're doing here is saying, well, there's no evidence, therefore it must be that they didn't investigate. That belies common sense, I think, but it was not put in the record that there was any irregularity in this.
for the purposes of our discussion, let me play devil's advocate with regard to the language and whether the proper procedure was found. Under 727-103, an asset in subparagraph that is defined as any cause of action you might have arising by contract. The estate has an asset by contract of insurance. The creditor would be whoever owed the money, the third party claiming the negligence. The estate belongs to the claim then is part of the estate of the debtor. The power given to the assignee under 0.108 includes the power to abandon a claim, the asset rather, any perfected asset, not to abandon the claim, but to abandon the asset. And the asset here is the insurance policy that would pay. And they can say, hey, we have no claim to it because the max of it will handle it. So they can either litigate the insurance asset or they can abandon it. In no case, if you did that procedure, would good faith come in from the trial court order. It would be determined upon the resolution of the asset to the estate. So my concern is, by the focus on a proof of claim, has the court followed an improper procedural track? And it should have followed the the asset of the debtor, which is the insurance policy, and either done in bankruptcy law, go litigate it and come back and tell me what the results are, or abandon it if the S&E said, it's not going to be worth it to us to litigate it. We don't have the money. There's no reason to. It's a maximum of $1 million. The debt is $2. We're just going to abandon the claim and let it go forth. You know, I'm concerned that we didn't do that we're not focusing on the asset and its resolution. We're focusing on a proof of claim, which is fine.
I think, Your Honor, it flows through to that, though, and that the asset was presented in the settlement as something that was made available to the.
Even though the titles are wrong, the argument is they followed the right procedure.
Yes, I think
Okay.
I think they did. Yes, I
get the argument.
because I think it makes no difference which you do, because the asset was provided in satisfaction of the claim. It would be a different situation. I would add that
If the asset is provided for the claim and it paid the maximum value, there's nothing more than the trial judge would have to do to a unrelated third party out there saying, hey, I have a debtor and I have a creditor and I approve the payment of it. And that's all the trial judge would have to say, right?
I think that's right. And yeah,
Wouldn't have to talk about good faith of anybody or I settled the claim based on whatever version of authority granted to I want to use the word trustee, but it's S&E.
well, I do think there's authority around the Kruger case that we cite in the brief. Indicates that good faith is a necessary component of any judicial approval of a settlement agreement. So I don't think it's out of bounds for the court to have dealt with that. And it's really expression. This is in the ordinary course, and it was as between parties that had adverse interests. So but I believe that what Everest did was totally in ordinary course, and but I think as the court has acknowledged, in bankruptcy proceedings, it's very common for bar orders to be entered. And I do think that, the Munford case in the 11th Circuit indicates how that should be addressed. And I think it's satisfied here. The bar order has to be integral to the settlement and has to be objectively fair and reasonable. And I don't think there's anything that Counsel for Evanston has raised that would even suggest that there is something not objectively fair and reasonable. They're saying, well, there could be. We want to have the right to challenge this, but there's nothing about our paying the full amount of the settlement, particularly in the face of their denying coverage, and our ensuring that the debtor is protected. So the debtor had no additional liability. It would, except for to the extent that the excess policy would create some coverage. So,
Mr. Toman, other than the stipulation, is there anything establishing that this was a single occurrence as opposed to a dual occurrence? And was there anything establishing the amount that is claimed in the proof of claim?
There is nothing, I believe, in the record, Your Honor, that would do that.
With that acknowledgement, I'm going back to the objection that the excess carrier filed. Once the objection was filed, is the authority in the court, is it so extensive that it can overrule the objection without taking testimony or evidence to address the objection?
Well, I would say you have to start first with the objection, Your Honor. No evidence was put forward that would substantiate the position that there was a problem. And so I would say when an objector has the burden of coming forward, at least creating some issue, and that was not done here.
Well, has the objector waived its assertions by not scheduling an evidentiary hearing? Or is that something that the assignee needs to do to move it forward? Because my concern, I mean, I think you can hear from the questions.
Yeah.
The concern is what is binding on the excess carrier as a result of this proceeding? And so, maybe they can prove that there was bad faith by the primary carrier. Maybe they can. Maybe they can prove there were two occurrences. Maybe they can't. But shouldn't those issues have been resolved in this proceeding before the court enters an order that basically approves all these things? The stipulation says it was all in good faith. It was negotiated in good faith, and there's only one occurrence. There are factual findings that are based on the stipulation over the objection of the excess carrier. And that's where I think you're hearing all the concern.
Well, I think, Your Honor, there needed to have been a well-founded objection. I mean, one that produces some support for the idea that there was some irregularity, some bad faith, or that there were, two occurrences as opposed to one. I think that to just say it but not put forward any evidence of that is not a valid objection and did not mandate the court going further.
Did the excess carrier ever advise the trial court that there needed to be an evidentiary hearing on these issues?
I don't believe so, Your Honor, no.
Let me
And
interject, since we have ridden a train of questions for a while, and I have not had a chance to tell Mr. Toman you're at 8 minutes because we're now at 11. So go ahead, Judge Silverman, ask the question. I just need to get that on record so that belatedly I performed my promised duty. Go ahead, Judge Silverman.
No, I'm sorry.
I'm going to give him time to answer.
I think, Mr. Toman, your position is that the excess carrier did nothing to preserve its objections by asking for an evidentiary hearing or presenting any proof. And I'm sure that Ms. Piercy will be able to respond to that when she gets up on rebuttal.
Absolutely. That's my position, Your Honor. There's no other questions. I will.
Mr. Toman, I'm going to give you the option, and usually counsel never refuses, of a minute to sum up, since we ran you from 8 minutes to 12 and you never got a chance to do anything but defend. And you guys have divided the time, which makes it a little bit unfair for everybody because there's some meaty questions here that we all need to get to. But go ahead, take a minute and sum up.
Yes, Your Honor. No, I mean, in sum, I believe that this bar order is consistent with bar orders that you would find in bankruptcy. It satisfies the requirements there. It was essential to the settlement, and you can see why. And Evanston satisfied its obligations under the policy and protected the interests of the debtor and paid the full amount. And I believe that that those critical facts, coupled with Evanston's denial of coverage throughout this, provides the context for the judge's order, which I think should be affirmed. Thank you.
Thank you, counsel.
Ms. Piercy?
Yes.
Don't go yet. Let me get the clock fixed here. My technological skills are de minimis. Okay, I'm ready. You have your full 5.
And you and I had an exchange beforehand. I think you finished your answer, and I have another question for you, which is, we understand that we have 2 different standards of review here: abuse of discretion for approving the settlement and de novo for interpreting the statute. What are we looking at here that isn't an abuse of discretion? Of client, the excess carrier's position in this appeal seems to me to be an attack on the settlement agreement and what's in there. And if that's, what are we, isn't an abuse of discretion?
Right, so abuse of discretion is the standard. If you look at a reply brief, we address that. And there's no competent substantial evidence supporting these findings. And that comes back to what was just discussed a minute ago. They want to say, well, Evanston had an obligation to prove that we didn't act in good faith, but they just came forward with a piece of paper that said we acted in good faith, this wasn't voluntary, and we negotiated. So rubber stamp it, and we'll hand over Everest, we'll hand over our policy limit, walk away.
In this context, with the assignee for the debtor and Conan Graham, the claimant, and the insurer that, you know, has a policy that may or may not provide coverage, and those are the parties to, you know, the dispute, the assignee basically for the insured and Conan Graham, and they're in the context of a liquidation, what this is. Why would there need to be anything beyond stipulation to garner the trial court's approval within the statutory framework?
Because what they agreed to implicates my client's policy at a time when my client, again, had no duty to defend because Everest owed that duty to Evanston. Everest cannot.
As Judge Silverman pointed out, your client was here. It didn't ask for an evidentiary hearing on any of that. So is that preserved? If you're going to sort of a traditional competent substantial evidence doesn't exist in this record to support what the trial court did or said in this order, then in the context of a 727, which definitely confers some unusual procedure, you know, some authority on the trial court that you don't see every day, how is this preserved?
It's preserved because it wasn't Evanston's burden to prove what they said. I can just come in and stipulate to anything in the world, and that doesn't mean that's fact. And that's the problem here. It was their burden.
It objected, and it didn't ask. It objected twice, but not to the proof of claim, but both times to the settlement, right?
It objected to the proof of claim, but it was in December. I can give you the exact date. It was later on. It was in December 9th of 2022. So it did not object to the proof of claim on the front end. It objected to it after basically the proceeding was reopened after the court. You know, if we look again at the initial order, the assignee comes in and says, close this out, there's 8,000 in assets. That gets approved. And then the proceeding gets essentially reopened in January. And then Evanston objected later on. So it was before a final order on approval of this proof of claim of Conan Graham's, but it wasn't before that initial order.
Ms. Piercy, I'm not sure I agree with you that your client had the right to object to a stipulation. I think your client had the right to object to the binding nature of things in the stipulation in terms of it binding your client. But I'm looking at the transcript from December of 2022. Is there anything in there where your client or counsel for your client says, Judge, you can't deal with our objection without an evidentiary hearing? We have raised factual questions.
No, that was not raised.
Isn't that problematic for your position that it's not the argument you're making as far as due process? How is it preserved in terms of us reversing?
So the due process argument is those findings binding Evanston. If Evanston is bound by them, then it does have a right to object, and it did object. And that's the problem. So we're basically told you're in a situation, and again, an excess carrier doesn't have any obligation at this point until that money of the primary is handed over. They have no obligation, but they're faced with object to this, or they're gonna argue you're bound by it. And that means you have no recourse but to file a deck action and hope you win. And if you don't win, that's the end of the story for you.
After the court entered its order, was there a motion for rehearing?
On the order here, no, there was not.
Okay, so I know there were proposed orders that were circulated. Was there an objection filed in the record asserting that the proposed order approving the stipulation goes too far because it has language that binds us and we haven't heard?
So if you look at the objections, so the order itself, and let me bring my timeline. The order was submitted and then the objection was filed. If you give me 1 second, I can pull that out.
I think once you conclude the answer to this inquiry, we will have gone beyond all.
Okay, and I apologize.
No,
Your Honor.
you know,
It-
the only person to blame is the one sitting center chair in cyberspace.
It was kind of you, Judge Casanova, to not blame the last guy who asked a question.
See?
No,
I'm so
I'm not
mature
even-
now.
So you had a joint motion for entry of a stipulated order and Evanston did file objections. It objected to the substance of what was included in this stipulation. Again, I think if it's going to be bound and prevented from ever being able to seek any recourse from Everest, that's the problem that we have here, because they hadn't, in excess had no obligation to come in, but now they're going to be bound and told you can't go after the primary. So that basically gives the primary carte blanche to do whatever they want. And they do have a duty of good faith and fair dealing to the excess. That's really the crux of all of this, is this was done without taking that into account. And now, as I said, if this is found to be enforceable against Evanston, then Evanston's hands are tied.
Thank you, counsel. That will conclude this matter. At this time, I thank counsel for their presentation today. We covered quite a bit of ground on this most interesting case, and I hope you all stay well. I know it's hurricane season out there, so stay well, stay safe. And with that, this case will be concluded. And as indicated before, we will take a short recess and be back at 12:25. Thank you. We are now in recess.
Thank you.
Thank you, Your Honor.